Here's another great question that we got on our private Legal Leverage Facebook group. For those of you who aren't familiar with our Legal Leverage program, it is a self-guided video program with a workbook that we send out that allows somebody who's considering bringing a claim against their employer on their own, or even if they're working with a lawyer and they want to be an educated consumer, it walks people how an attorney would evaluate your case, for instance, to decide tactically how much to ask for, what kind of claims to file, to really walk you through step by step, kind of nuts and bolts, how an experienced attorney would think about this. And as part of that, you get access to our private Legal Leverage Facebook group where you can post anonymously questions and we'll answer them. And so here's one. I'm not going to read it exactly because these are anonymous, so I would respect that. But in essence, it's about a person who has brought a claim against their employer and has experienced difficulty with her own lawyer. And she has questions about what are the parameters about what a client can control and what the lawyer controls. What happens when you're with a lawyer who's kind of like not being very nice to you? Maybe you're asking questions and they're being either non-responsive or kind of lashing out at you. And then how can a client manage his or her own emotions going through this process, which is a great question because there is the trauma that you experience from what happened at work, and then there's going to be trauma experienced in going through the process, even if things go great, because it is a stressful ordeal to go through to bring these claims. And as part of Legal Leverage, we talk about how to manage that from a legal perspective. The longer you go in a case, the more stressful it becomes, but also the bigger the payout, both potentially to you financially and the potential that you might enforce some kind of change at the company. You can get things done earlier in the case and experience less distress, but you're often going to get a smaller compensation. The check to you is going to be smaller, and the company is probably not going to make any changes because they're able to sweep this under the rug. So all tactical decisions that you have to make when going through this. The first question is a good one. Like, what are you, when you go hire a lawyer, right? You're hiring him or her for their expertise, but it's still your case. So what do you have control over and what does the lawyer have control over? And this is mostly governed in every state by the Bar Association. And every Bar Association has rules of professional conduct, and these are enforced. So if a lawyer violates, a rule of professional conduct, then, the bar can conduct an investigation. But under these rules, generally, lawyers have the final say in how and the procedures involved with a lawsuit. For example, like, do I file this complaint or, this cause of action, or don't I? Do I, grant the opposing party's request for an extension, or don't I? Do I make this legal argument, or don't I? So the attorney has the final say on that because they're the professional who's bringing these claims in court on your behalf. You, as the person who this is about, it is your case. You have ultimate decisions on whether or not you continue with this attorney, right? You can fire an attorney at any time for any reason, but for no reason at all. And that's solely within your control. You have sole authority about whether or not to continue with the case, right? So if at some point you're like, I am done with this, I just want to dismiss it, your attorney can't just go on, without your permission. Only wrinkle there is if you're in court already. Sometimes you'll have to get permission from the court to dismiss, but usually you will get that, court's going to grant that. So you have ultimate authority over, whether the case proceeds or not, and you have ultimate authority over settlement, okay? So if you are, let's say you've gone to mediation and the other side has offered a settlement that you don't like, and let's say your attorney says to you, like, this is ridiculous, like, you have to accept this settlement. You don't. You have ultimate authority about whether you accept that settlement or not. Now, the attorney does have the option to get out of the case at that point. So they can say, if you're not going to accept my professional advice, I'm going to get out of the case. But they can't make you accept that settlement, and they can't make you reject one, right? So let's say you get a settlement offer, the attorney says, hey, this is way too low, we can get you a lot more money, but you're ready to be done with this, fine amount of money for you, and you want to take it, and the attorney's like, I completely disapprove. He or she has no authority over that. You can accept that agreement. Everything else is within the attorney's purview. So again, the legal arguments to make, how to make them, the procedural aspects of the case, the attorney has the final say over. But again, just as in the example I raised earlier, where an attorney can get out of the case or try to, if you reject what they consider to be a reasonable settlement offer, you can fire an attorney, right? If the attorney says, hey, I'm not willing to bring this claim, I think it's too weak, but you want that claim brought, you can fire the attorney and find someone who will bring it for you. And again, you don't have to have a reason to fire an attorney at all, but that is an option for you. Now, that said, in most instances, the attorney should be working with you. I mean, certainly in our firm, we try to, work with the client, and where at all possible, if it's an argument that the client wants to make, unless it's completely improper or we think it will damage the case, which sometimes those things happen, we're going to make that argument. I mean, we might tell you, hey, we think you're going to lose this one. It's a weak one, but if you want us to make the argument, we're going to make the argument. Hey, you want to proceed quickly in this case and file these motions, or you want to proceed slowly and you don't want to file them, we will be listening to you, because it is your case at the end of the day. So most attorneys should be at least talking with you about them, and it should be rare that an attorney is telling you, kind of my way or the highway, because it is a collaboration. So your attorney, hopefully is listening to you. I think this person who's asking this question is having the opposite problem, and the attorney's not only trying to drive all the decisions, but it sounds like not being particularly responsive, and if he or she is responsive, being upset with the client. Sadly, this is not entirely uncommon. Who knows why the attorney is doing this? Litigation is stressful for attorneys too. Running a law firm can be difficult. You can be having all the things that we all experience, right? This attorney can be having a problem at home, just may not have a high emotional IQ, and, is a good litigator, but has a terrible bedside manner. And unfortunately, that does happen. I can only say I'm sorry that you're experiencing that. And the other question that was asked is, what are the possibilities if you're in that's like you said, like if you're in a jurisdiction where it's more employer friendly, and perhaps the vibe of the bar there is also more socially conservative, or like doesn't accept kind of people who speak up for themselves, whatever, which sometimes we see that, and you feel like you have limited choices, right? Because you can always fire that lawyer and find another one. You feel like you have limited choices. You can go outside of the jurisdiction, absolutely. There are attorneys now the attorneys has to be barred in that jurisdiction or willing to get local counsel. Very common, where let's say, for example, like I'm barred in Virginia, DC, and North Carolina. If I wanted to bring a case in California, I can do that. I just have to get local counsel. Very common. So local counsel files what's called a pro hoc vice motion for me, which allows me to appear just on that matter. Again, this is very common. Depending on the jurisdiction, the local attorney may have to come with you to hearings and things like that, but essentially I'm able to conduct the case. So you can find attorneys absolutely who are outside of your jurisdiction who will do that and have the capability to do that. And sometimes you need to do that, particularly if it's a very powerful employer. You may find it difficult to find a local lawyer who's willing to take your case to go against this employer, because they are so powerful and they don't want to end up on the wrong side of them. So it's not uncommon at all to have to go outside of that jurisdiction to find somebody who is willing to to bring this case against this powerful employer, because they're not in the jurisdiction and they're not afraid of this employer. So it's absolutely possible to look out of state. So broaden your search. Obviously you want people who are familiar with that area of the law. Sometimes attorneys don't want to do it because, while employment law, a lot of it is federal, there are a lot of differences between state and localities. So an attorney wants to make sure that he or she feels like they can adequately represent you, again, which is often not terribly difficult. You can, again, through local counsel, learn what the local laws are. They're often not so different from federal laws that an attorney can't quickly figure them out. So there are ways around that. So yes, absolutely broaden your search. Look nationwide. You might find a lawyer on the other side of the country who's willing to bring your case. And then the final question is, how do you deal with the emotional trauma? If it's being caused by your lawyer, then you need a different lawyer. But otherwise, how do you deal with the emotional trauma that you experience from the workplace event, and then the difficulty of going through litigation, right? Because as we said, it's very stressful, and it is entirely possible to get re-traumatized through this process. And my advice would be to find a mental health professional. Attorneys, we're used to dealing with this. We're happy to talk to you, but we're not therapists. And sometimes, as I write about in my new book that's coming out, you don't want your attorney to be your therapist, A, because they're going to be more expensive than your therapist, and B, they're not a trained therapist. Absolutely, they should listen to your emotional issues. They should be sympathetic. A good attorney will be all of that, but they're not professional healthcare professionals. I would work with your attorney to find somebody who you can talk to, a therapist, because these are real issues and you want somebody to help you deal with that. I'd say work with your attorney because it is possible that your therapist could be called as a witness, in your case. If you brought up emotional distress because you've experienced emotional distress, well, the employer is going to want to talk to anybody who has knowledge of that. Now, there are protections for therapists. They may not be able to force them to testify, but your therapist should be prepared for that. And it may change how he or she, for instance, like he or she may decide not to take notes because they don't want to have to then turn over notes to your employer. But so I would say hire a professional, work with your attorney, or at least let your attorney know that you were doing that. Let the healthcare professional know that you're working with, know that you have a case ongoing, because they can best help protect you if they know what's going on. So I hope that helps. I'm sorry that you're experiencing these difficulties. I know it can be overwhelming, and I hope you're able to find somebody who can truly be an advocate for you and you can get some real justice.